Hello, and welcome to our newest installment of Ask John. We're joined today by scholar John Kaminsky from the Center for the Study of the American Constitution. John, I'd like to ask a couple questions about Unit 1. We've had some questions come in from Arcadia High School in California. First of all, if moral education was such an important idea for the founders, why isn't it in the Constitution?
It certainly was an important factor of both religion and morality. The founding generation believed that this was extremely important to maintain order in society, which was critical, and also to have a good government from both the perspective of the people and the governors of the people. So there's no question of the importance of religion and morality. The sense was, however, that this was not a concern for a federal government. It was a concern of the family to have education and religious training. And it was also a state power, a state authority. And you'll find in various of the state constitutions provisions for educational institutions and support for education, as well as support for religion. And so they just felt that it was not appropriate at the federal level to have this authority. And that's particularly true of religion because there were so many different religions in America that there was a feeling that the federal government should not get involved in either favoring or supporting one different sect as opposed to another. There just were too many of these, and it was safest to stay out. And so it was not an area that the government should be involved in. I should note, however, that of the first 7 presidents, 6 of them proposed a national university. And so there was the sense that there should be some kind of educational institution that would be have a national perspective.
Let's shift gears a little bit, and one of the questions in Unit 1 has to do with this idea of self-determination. Where in the founding period, documents or Congress or court decisions, do we see this idea of self-determination?
Well, self-determination can be looked at from 2 broad perspectives. One is national self-determination, and the other would be more individual person. And so if we look at the national self-determination, obviously the Declaration of Independence states that in those first, the preamble to the Declaration that Jefferson wrote, those first 5 sentences, 202 words, in which he states the American philosophy of government, ending up with in essence, the right of revolution, and that the people can in fact decide what kind of government they want, and if a government is oppressive and doesn't respond to alleviating the grievances of the people, the government have the right, the people have a right to overthrow that government. And so that's exactly what happened with the Declaration of Independence and the War for Independence. They stated philosophically that the American people have the right to establish their own government, and then they established it by conflict. It was not going to be a gift given to them by the English people, but they were going to have to, the Americans were going to have to wrest this away and establish their own independence. So this was the American point of view for subsequent revolutions in encouraging change in England, but then particularly in France when the French Revolution comes along. There's a great divide over that, over excessive democracy from the point of view of those conservatives in America, but those who are more liberally minded, the Jeffersonians, who are somewhat supportive of the France as opposed to England at this time, they would argue in favor of the French Revolution, that the French people have the right to decide what kind of government they want to have. And the Americans certainly were advocating that Americans, should be an example of a Republican form of government, which they felt was the best form of government, and we should lead by example and hope that other countries would follow in the direction that we had taken and establish Republican forms of government. Now, on an individual basis, if we look at the Constitution, we can see that there are provisions that Anti-Federalists would argue counteract the self-determination of what kind of government people would have and how much an impact the government would have on them and on their choices. So the Anti-Federalists objected to the fact that the terms of office were longer, 2 years for the representatives, 6 years for the senators, and 4 years for the president. This was unacceptable to Americans in the eyes of Anti-Federalists, who were used to annual elections for their legislatures and their governors. There were a few exceptions to that, but maybe in a couple states, 2 years for the representatives, and at the longest, 3 years for the governor in New York. So these 2-year, 4-year, and 6-year terms for federal officers were felt to be violative of what they said was necessary free and frequent elections. So the biennial elections were unacceptable to opponents of the Constitution. They also objected to the fact that recall was taken out. That was a provision in the Articles of Confederation. If people were dissatisfied with their delegate to Congress under the Articles, they could recall that person. That's not possible under the Constitution. No provision, no explicit provision for such a recall. There's no mandatory rotation in office, which means those folks who are in will perpetuate themselves, making it difficult for people to elect somebody else. And so that mandatory rotation that was in the Articles of Confederation is removed from the Constitution. And part and parcel of the recall, there is no provision for instruction. And that was implied under the Articles with the recall. If the delegate to Congress didn't follow instructions, that delegate could be recalled. There's no reference to recall in the Constitution, as I mentioned, and no mention of instructions either in the Constitution. Now, the Federalists argue from a different point of view. They said, under this new Constitution, the people will elect their representatives to Congress. That was not necessarily the case under the Articles. Under the Articles of Confederation, it said that the state legislatures could determine how delegates to Congress were elected. And in fact, 11 of the 13 states, the legislatures elected delegates to Congress. Only in Connecticut and Rhode Island were the delegates to Congress elected directly by the people. And so the Federalists would argue the Constitution is much more in line with self-determination for people to elect the delegates to Congress, the representatives to Congress, and indirectly electing senators and the president and vice president. Now, from another perspective, self-determination also means, to a certain extent, sovereignty of the people. And the Federalists would argue that the Constitutional Convention seized upon this initiative, and they acted as direct representatives of the people, and they violated their instructions and came up with a brand new form of government that they proposed, and that was perfectly legitimate. And it was only, after all, a suggestion, and the people could reject it. But they did this because of the feeling was that the Constitutional Convention was a constituent body of the people, and they could do anything that they wanted to do. Even though Anti-Federalists pointed out that the Constitutional Convention was not, those delegates were not appointed by the people directly, but were appointed by their state legislatures. Now, ironically, the Federalists turn around and they have a contradictory position about the state ratifying conventions. These were truly constituent bodies of the people. They were all elected by the people, not by the state legislatures. But the Federalists said that these state ratifying conventions could not propose amendments to the Constitution. And so on one hand, the Federalists were arguing that the Constitutional Convention could do anything that it wanted because it was a constituent body of the people, even though it wasn't. But then on the other hand, the constituent body of the people, the state ratifying conventions, were limited in what they could do. And so this whole argument of self-determination is viewed differently by different folks at different times.
I'd like to follow up a little bit, John. Many people don't know that there was a lot of objections to the federal control of state elections. How does that play into this idea of state sovereignty and self-determination?
Yes, that's found in Article 1, Section 4, in which it says Congress has the right to regulate federal elections, that is, the elections of representatives and senators. They can determine the time and the place and the manner of electing, not the place for the election of the senators, because senators are elected by state legislatures, and it was felt Congress shouldn't tell the state legislatures where they ought to meet. But a lot of people objected to that clause, not just anti-federalists. A lot of federalists objected to it also. The argument in favor of that clause, of Congress having the power to regulate federal elections, was that what happens if a state is invaded and occupied, as was the case in South Carolina and Georgia during the Revolution? They can't hold an election. And so Congress had to intervene and call the election outside of the state. And so Carolinians and Georgians outside of the state would elect their delegates to Congress. And so that was an argument. If a state is invaded, the second side, another possibility, would be what happens if the state refuses to elect delegates to Congress, representatives to Congress, or senators, as Rhode Island repeatedly had done in Congress, and Rhode Island didn't send delegates to the Constitutional Convention. And therefore, in these two cases, in cases of invasion and in cases of a state not participating in federal elections, Congress should be able to intervene. The anti-federalists said, if that's what you believe, why didn't you put it in writing? Why didn't you say in these two cases Congress could intervene? But they left it wide open, and so the anti-federalists said, this is just a method that incumbents are going to use to encourage and ensure that they will be reelected. They could very likely hold the election for representatives, let's say in Pittsburgh, would be the only place for polling, and no other place in Pennsylvania. Now that's pretty far-fetched, but that was an exaggerated position that they're putting forth, that this was an attempt by Federalists to favor the re-election of incumbents.
Let's go to the personal level. Is there any, if any, relationship between personal self-determination and, say, the rights in the Bill of Rights?
Well, certainly the opportunity for self-determination for individuals has two sides. One would be the official side concerning elections and various provisions for office holders. But on the other side, there's a certain degree of freedoms that individuals should have, whether they be natural rights or whether they be written down in the founding documents, in this case, in the Bill of Rights. And obviously, when you're talking about freedom of religion, freedom of speech, freedom of press, freedom of assembly, freedom from excessive search and seizure, protection against quartering of troops, all these things are protecting the rights of individuals, in essence, guaranteeing self-determination of these individuals. And so they saw this as an important provision that was initially not in the Constitution and therefore endangered the self-determination of individuals, and that such a Bill of Rights was necessary to guarantee the self-determination of all Americans.
I'm going to ask you to speculate a little bit, John. We have a question. We have a question from a student. And asks, is the death penalty constitutional?
I would say there's absolutely no doubt that the death penalty is constitutional. It was in place in every single state at the time. There's nothing in the body of the Constitution that would argue against the death penalty. If you look at the Eighth Amendment to the Constitution, which is passed afterwards, over 2 years later, after the Constitution is adopted, you get the Bill of Rights adopted, and within that, the Eighth Amendment, saying that there should be no cruel and unusual punishment. The death penalty was not thought to be cruel and unusual. It was depending upon how you administer it, that could be cruel and unusual. And so, for instance, when Thomas Jefferson left Congress in 1777, he went back home to Virginia, and he was elected to the House of Delegates. There he chaired a committee of 5 that was to recodify the laws of Virginia. And what they did was they reduced the number of capital offenses from about 40 down to 2. So it can only be executed for 2 crimes. One was murder, the other was treason. And so there was an amelioration of the laws. It was a gradual thing happening throughout the colonies, throughout the world, really, the Western European world, to reduce the vigor of the law. But there were various provisions, various statements by people saying that any government that would try to eliminate the capital punishment would be wrong, both from a historical point of view, but also from a biblical perspective. The Bible was cited over and over again, an eye for an eye, a tooth for a tooth. And the Almighty had instructed Noah that there would be anybody shedding blood would have to shed his own blood as compensation for what he had done. So it was felt that capital punishment was perfectly just from both a religious point of view and a moral perspective and a governmental perspective, but that there should not be excessiveness, that it shouldn't be drawing and quartering, shouldn't be slitting of noses and cutting off ears, things like that. That kind of punishment should, the rack, those kinds of punishments that were so prevalent that often were used to coerce confessions. That kind of thing was disallowed under the Eighth Amendment, cruel and unusual punishment. But it's interesting to note that they would often think of long-term incarceration as cruel and unusual. That is, penitentiaries, a 10 or 20-year sentence, was cruel and unusual and should not be provided for. Death was far less onerous than this long-term incarceration. It wasn't until Cesare Beccaria came along, an Italian political philosopher, that he advocated the penitentiary, penitence, the word penitentiary comes from the word penitence, and advocating that kind of punishment as opposed to capital punishment for many crimes. So if we're looking at the original intent of the founders, you could very easily say that they believed that anyone convicted of a fairly modest crime in today's point of view, let's say stealing a car, home burglary, etc., in highwaymen, that is, accosting somebody in the open and robbing them. All these things were capital punishments back 200 years ago. And if we wanted to interpret the Constitution literally and from the intent of the founders, that's what we would have to do. Say that those people guilty of those kinds of crimes today could be executed. I don't think any of us would like to see that happen.
Thank you, John, and thank you for joining us.